people, and they would focus on maintaining the decorum in their courtroom at all times. As a judge, there are times when you have disgruntled litigants or an unruly spectator, or, like I said, an unprofessional attorney. The judge has to be able to manage that and control the courtroom.
All right, the new question in the area of character will go first to Chuck. Describe a challenging ethical dilemma you've encountered in the courtroom. How did you handle it?
Challenging ethical dilemma in the courtroom.
Or as an attorney?
I reported it to the Judicial Conduct Board. I've never personally had an ethical dilemma. I stay away from those things. But I've seen judges do things that they should not be doing. And you're obligated, if we see another attorney doing something unethical, we have to report it. We get in trouble. Judge does something, we need to report them to the Judicial Conduct Board. I remember a year ago we had a seminar in this very room, and the Judicial Conduct Board was here and said, if you see a judge doing something they shouldn't do, report them. And the last time I had one of those ethical problems was reported to the Conduct Board.
Tom?
Two examples come to mind that happen all too frequently in our profession. One is when your client is lying to you, and the other is when you have evidence that you must produce in a case that even though it's going to be harmful to your client. And we have absolute ethical standards that apply to both situations. You may not allow your client knowingly to lie. You may not support that. To obviously logically to further that in any way. So there have been many times when I've had to confront clients that I knew were lying, and when I was not able to resolve that, we had to withdraw from the case. With respect to the production of evidence, we have in civil cases, which I'm sure many of you know, is discovery, where each side discovers what the other's case is about, which involves the production of documents. Many times in my career where there have been documents that were not favorable to my client, which I had an absolute duty to produce. And I often had conflicts with other lawyers that I was working with where they didn't agree with that, they didn't agree with ways in which the production could be avoided, and I didn't agree with that. And these are issues that are critical, I think, to become a judge. The judge has to have absolute integrity.
As a prosecutor, I have special responsibilities under the rules of professional conduct that go beyond that of other lawyers. It requires me to be a minister of justice. There have been two instances in my career as a prosecutor where defense counsel did not request information through the discovery process that I knew would affect the outcome of the case. In the first instance, it dealt with how the chain of custody was maintained on evidence. And upon that discovery, which I made on the day of trial, I went in chambers and disclosed it both to the judge and the defense counsel. On a second occasion, though I had a defense attorney who was willing to have his client enter a plea, I believe that that defense attorney's abilities and judgment were impaired that day. So I was given the unenviable task of reporting that to the judge in that attorney's presence and dealing with that fallout. But that's the duty of a prosecutor. It would have been very easy to pick up those convictions, but my duty required that I disclose them. And I think similarly as a judge, that's one step further in terms of being a minister of justice. It's not the result you're seeking for your particular side. As a judge, the judge has to do what is fair, what is just, what is right.
Blaine?
Well, as Mr. Fallon said, I have had occasion over the years where I have suspected clients might be untruthful or may have want to change stories, and I've had to strongly counsel them to not do so. And I've had a couple of occasions over the years with judges in particular that I thought were acting very inappropriately, not in our county, but in other counties. One judge in Fayette County berated me for being an out-of-county lawyer and wanting to represent somebody from Fayette City. And it was actually a good friend of mine. And I took exception to that. I could have probably made a complaint about the judge, but I went and talked to him privately, explained my position, basically stood up to him, and I think earned some respect for him from that point onward. The second judge in Westmoreland County did not like my previous law partner and would always make disparaging remarks about him at the call of the list whenever I would go. So I, at one point, had enough of it. I stood up and told the judge that I didn't think it was appropriate. Also went back in his chambers and spoke with him. And again, I think I earned some respect from him at that point. These are things that I probably could have turned the judges in on or made a complaint, but I chose not to. I think a judge has to have the temperament, the proper temperament to deal with things like that, and I think I do have that. Thank you.
All right, we're gonna break up the longer questions with our quick question round here. And we'll start with Blaine, and then everybody will answer these questions. The first two questions we did give to the candidates ahead of time because it was asking them for sort of a number or a percentage, and we wanted them to be able to think about that to have the accurate information when they came tonight. So, and this first question will allow 30 seconds if you need it, but the others, again, we're going to try to keep to no more than a sentence or two. So this question will address your trial experience. How many jury or judicial trials have you litigated, regardless of whether it's settled and went to judgment before a judge or jury? Or, if you prefer to answer it in terms of how many bench or jury trials you have tried to verdict. Either you can answer either of those.
Well, as far as bench or jury trials tried to verdict, I've been practicing 32 years. I have to estimate that I've had at least 150 to 200 cases tried to verdict. Civil cases, automobile accident cases. I've tried cases in many counties, 5 surrounding counties to Washington. I also am the solicitor for the Washington County Tax Claim Tax Assessment Office, and I do numerous bench trials on a yearly basis handling tax appeals.
Pete.
Being in criminal defense, family law, and other areas, I think the most proper way for me to answer this question really is number 2, because I couldn't tell you in regards to number 1. I would say a conservative estimate is going to be over 100 bench and jury trials in the last 9 years.
Lane?
This was a difficult question, it really was, to try and quantify your career, because I personally don't keep score. I think most lawyers are probably that way. I think the question was litigated, cases we've litigated, not tried. Is that correct, Heather? Right?
That was the way the question was
Okay.
first shared with you.
Great.
Yeah.
But I've been in private practice for 13 years, but I was also a DA. Jury trials as an assistant district attorney, I would say at least 15 to 20. But as far as bench and other civil trials, I'd say well over 300, not to mention the thousands of cases that I handled as a DA and others.
Alan?
I also don't like to quantify things. I think there's something wrong when an individual actually keeps a scorecard of the number of cases that they've tried, either as a prosecutor or defense attorney. Certainly in the Army, when I was a litigator, the position of the Department of
Defense, and in particular Secretary of Minority, was you litigated